I'm Jessica Saunders and I work within the Civil Liberties Department at Stephensons Solicitors. I specifically deal with actions against public bodies, which are civil claims for monetary compensation. My team and I deal with a variety of different types of cases. Some examples of the types of cases we deal with are false imprisonment, a breach of the Human Rights Act, a breach of the Data Protection Act, assault and battery, malicious prosecution, unlawful arrest, negligence, misfeasance in public office, and trespass. We mostly pursue claims against public bodies such as the police, the prison service, the court, and local authorities. Some examples of our successful cases are a claim involving a breach of the Data Protection Act by the local authority who incorrectly released the address of the adoptive parents to the child's birth parents. The adoptive parents approached us at an extremely worrying time for them, as the safety of their family had been compromised. As a result of the data breach, they had to move house, and we were able to support them throughout this stressful time. We were able to secure a successful outcome for the family, who were reimbursed for the cost of the move, as well as receiving compensation for the distress they had experienced. In another case, we successfully sued a local authority for their failure to remove a child where there was severe neglect and abuse within the family home. This was an extremely upsetting and delicate matter to deal with, but we were able to support the client every step of the way. We ultimately secured a six-figure settlement for the client in this case, and whilst they could never undo the damage caused by what happened, the result has gone some way towards enabling the client to rebuild their life. Another example is where our client had been arrested and held in a police station for a number of hours due to a mistake by the police who'd issued the warrant against the wrong person. This is a good example of the overlap that can be involved in these types of cases, as we pursued the case on the basis of false imprisonment, a breach of our client's human rights, a breach of the Data Protection Act, and also for the psychological trauma experienced as a result of the whole ordeal. Our client received several £1,000s of compensation as a result of what had happened. There are several different ways to fund these types of cases. The first is legal aid, or in the first instance, a scheme called legal help. Legal help is used for all pre-action work, meaning all work completed on a case up until the point the court is involved. Legal aid is more commonly used once court proceedings are required. These are both types of public funding and are subject to you meeting the eligibility criteria. If you're receiving benefits, you may automatically be eligible for this type of funding. If you're on a low income, then these schemes may also be available to you, but will be subject to you meeting the required threshold. The second way to fund these types of cases would be to pay us privately. We can offer competitive rates and can sometimes agree to a fixed fee, so you don't have the worry of incurring additional or unexpected fees. The final way these matters can be funded are under a conditional fee agreement, also known as a no-win, no-fee agreement. This is an agreement between us that means that subject to certain conditions, you don't have to pay us unless you win your case. The types of funding available to you can be discussed with the team when you make your initial inquiry with us. We can then work with you to decide how best to fund your case. If we can help you, then once the case has been passed to my team, we'll speak to you in more detail to establish what, how, and when things have happened. We may ask you for copies of any documents you have that support your case, so it's always important to keep any document relating to the matter in a safe place. Once we have all the information from you, we can then draft a letter to the defendant which sets out the circumstances of the incident, why we consider the defendant to be at fault, and what you're seeking to claim as a result. This letter is called a letter before claim. We will send this letter to you to check it's accurate before we send it to the defendant. Once the letter's been sent to the defendant or the representatives, the defendant then has a period of time to investigate before providing their formal response. The defendant initially has 3 weeks to acknowledge the letter, and this then gives them a further 3 months to investigate the allegations. If the defendant admits responsibility for what's happened, then we'll try and negotiate how much your claim is worth. Before we can do this, we sometimes need some additional documents from you to support your case. For example, receipts, medical records, or even a medical report. This isn't always needed, and in some cases, we can agree how much the claim is worth without any further evidence. If the defendant denies responsibility for what happens, then they have to provide us with evidence to support this. We will review any documents provided to us and then advise you of what happens next. If we ultimately can't reach an agreement with the defendant, either about who's responsible for what happened or how much the case is worth, then we may need to issue court proceedings. This could mean that your case will go to trial, and if it does, a judge will decide firstly who's responsible and secondly how much the case is worth. There are two elements to these types of claims. There's something known as general damages, which is compensation for any physical injury you've sustained or any psychological symptoms you may have experienced. So for example, if you've been arrested, then you may have sustained cuts and bruises during the arrest, or even broken bones in more serious cases, as well as feeling upset and distressed about what has happened to you. All of these things are considered when we calculate how much this part of your claim is worth. The other type of loss is known as special damages, which are financial losses that you have incurred as a direct result of the incident happening. Using the same example, If you were arrested, you may have had to take time off work and not been paid. Your clothing might have been damaged whilst you were arrested, and you may have had to pay for a taxi or other transport home from the police station. Subject to having evidence to support this, these are all things that could be included within your claim. How much your claim is worth depends on a large number of factors. As you can see from the examples given at the start of this video, the amount of compensation will vary dependent on the type of claim you're pursuing, how the incident has impacted you, and what losses you've incurred as a result. Unfortunately, it's impossible to give you an idea as to how much the claim could be worth until we've spoken to you directly. But once we have, we can give you an idea as to how much compensation you may be likely to receive. How long you have to make a claim depends on what type of claim you're pursuing. The rules that govern these types of cases mean that unless certain exceptions apply, if you don't issue court proceedings in time, you can lose your right to claim compensation. As the previous examples show, we deal with a lot of different types of cases, and sometimes cases that involve a number of potential issues. The deadlines that apply to your particular case will therefore be discussed with you at the outset of your inquiry with us to make sure that these aren't missed. Some common examples of deadlines are: if you're pursuing a claim for a breach of your human rights, you have 1 year minus 1 day from the date of the breach to bring the claim. If you sustained any injuries as a result of what happened, whether these are physical or psychological, you have 3 years minus 1 day from the date of the incident in which to bring a claim. For claims for negligence or any breach of the Data Protection Act, you have 6 years from the date of damage or the date of the breach. To make sure you don't miss any potential deadlines, it's always best to contact a solicitor as soon as possible. Our team can advise you on the time limits in relation to your individual claim and will ensure that these are complied with on your behalf if we're instructed to deal with the case for you. If you think that you may have a case involving any of the types of claim my team deal with, please don't delay in contacting us and seeking formal legal advice. These are specialist and often complicated claims, so securing the proper legal advice from the outset is crucial. Our initial contact with you is completely free of charge, and we're usually able to let you know if we can act for you within 48 hours of making your inquiry.